The directive does not define what we to understand under contract performance conditions. However, from Article 70, it follows that public buyers may, meaning they have a right, not an obligation, to lay down special conditions relating to the performance of a contract. Performance conditions mainly relate to social and environmental consideration. They must be included in the procurement documentation or the call for tenders and be linked to the subject matter of the contract. The link to the subject matter of a contract requirement prohibits public buyers from applying a general corporate social or environmental responsibility policies within performance conditions. Therefore, requiring the contractor to, for example, invest in overall production capacity of renewable energy or to establish a company diversity hiring policy is prohibited. In this context, it is worthy to remember that mandatory environmental and social standards concerning the supplier are enforceable under Article 18.2 of the directive. The indication in Recital 97 prohibiting requiring corporate social responsibility must be read as a prohibition to impose higher than mandatory standards on suppliers only insofar as they are not relating to or go beyond the contract subject matter. The performance condition can generally be grouped into two types, which I will be discussing further. First of them are the environmental performance conditions, and the second one are the social performance conditions. To start with the environmental ones. Performance conditions relating to environmental considerations might be applied to protect environment or animal welfare. For example, production or provision processes. That follows from Recital 98. In the context of the supply of goods, they could require that purchased supplies manufacturing does not involve toxic chemicals. Terms of delivery are often the subject of performance conditions for the supply of goods. In practical terms, this could mean including requirement for reducing deliveries by, let's say, 85%, or from daily to once or twice per month. The supplier can be required to take back and recycle or reuse any packaging that comes with the product. It is also possible to require a supplier to report on greenhouse gas emissions caused in delivery of supplies and indicate measures taken to reduce or offset them. This could be a payment or planting of trees. Performance conditions for the provision of works or services can relate to waste minimization, training of the contractor's staff, or resource efficiency in respect of works and services performed. For example, as in Buying Green guide that has been produced by the Commission, example of Italy, where a contract for cleaning services included a clause requiring contractor to implement an informal environmental management system for the services provided. The contractor was required to carry out initial environment review of the service, initialize the environmental program, and then ensure steps are taken to monitor such a program. Now, the second type, the social performance conditions. The catalog of social performance conditions is broad. It contains possibilities to include requirements to employ disadvantaged persons or members of vulnerable groups such as long-term unemployed persons or persons with disabilities as part of their workforce used in implementing the awarded contract. For example, Bentia's case. They can also relate to implementing training measures for the unemployed on young persons, or to pay a certain wage to workers under procurement contract, as the case in Regio Post. Or they can also require products to be supplied, or the products that are to be supplied that must come from small-scale producers in developing countries, subject to trading conditions favorable to them. That follows from the Dutch coffee. Finally, the Aristotle 1980 suggests that performance conditions can even be used to promote the level playing field in the context of gender equality in the labor market by favoring the implementation of measures for promotions of equality of women and men at work, the increased participation of women in the labor market, and reconciliation of work and private life, and to comply in substance with fundamental international labor organization conventions, and to recruit more disadvantaged persons than are required under national legislation. So now on to what is the character of contract performance conditions. Performance conditions are closely connected to the technical specification and award criteria. The distinction between technical specification and performance conditions get particularly complicated regarding aspects connected to supply production. In Dutch coffee case, the court stated that products requirement to be from organic agriculture was a technical specification. However, the fair trade requirements relating to products cannot constitute technical specification, but rather they are performance conditions. This conclusion was drawn based on an argument that the definition of technical specification relates to manufacturing, and fair trade is perceived by court as conditions under which the supplier acquires them from the manufacturer. Performance conditions are facultative, meaning they may, but they do not have to be included in public procurement process. That is left to discretion of contracting authority to decide whether they want to have them or not. However, if included, they usually have a mandatory character and constitute fixed objective requirement that has no impact on assessment of the tenders. That follows from Recital 104. That means that the performance conditions are withdrawn from a competitive phase of public procurement process. Instead, they are minimum requirements of a pass-fail character in which the contractor must fulfill them. Enforcing compliance with performance conditions is not as straightforward as one would hope. As a starting point, it follows from the Bentius case and also from the case Commission versus Italy that a public buyer cannot reject bidders solely because it considers the bidder unable to meet the performance conditions. The ability to fulfill performance conditions is not part of a professional or technical ability, which are the ones that we're looking at the selection process. However, Article 56.1 of the directive provides that public buyers are to verify compliance with, amongst others, conditions set out in procurement documents. Suppose performance conditions are indicated as a mandatory requirement in the procurement documents. In that case, the public buyer shall or must exclude a bidder from the procurement which does not accept advertised mandatory performance conditions. This has been confirmed in the Regia Post case, where the court confirmed that the public buyer had the power to reject tender that did not accept a requirement to pay a minimum wage under a public contract. This is a type of a formal check based on the tender's documentation. During the award procedure, the public buyers are thus limited in their ability to assess the possible future non-compliance with the forward-looking requirements. This may create issues in terms of transparency and fair competition. Compliance with the performance conditions must therefore be verified during the contract implementation stage. Otherwise, the public buyer will rely on false claims, and potentially unreliable tenders may distort competition. The last topic or aspect of this topic that I would like to cover is the minimum wage as a contract performance condition. In recent years, consideration of labor law and social protection of workers, specifically the question of minimum wage as a special condition in public procurement contracts, have been much discussed following the European Court of Justice cases in Rufer, Bundesdruckerei and Regia Post. These cases analyze the compliance of performance conditions through the lens of public procurement law and Posted Workers Directive. In these cases, the court found that the ability of public buyer to introduce social consideration in terms of minimum wage in procurement procedures was limited, particularly in the first two cases, by the specific conditions in the Posted Workers Directive and by general EU law. The CGU 2014 decision in Regia Post shows a somehow more open approach to balancing social consideration and provision of services in public procurement.